Morning, guys. Heading out to the range today with a couple buddies, get some trigger time in. Not teaching today, just again, I need some trigger time for myself, so that's what I'm doing. But unrelated, I want to talk about a little Illinois concealed carry law. A question came up from a fellow copper that asked my opinion on, does the firearm, a handgun in this context, need to be concealed while in the vehicle under Illinois concealed carry law? And I was like, great question, dude. There is some conflicting language in the statute, obviously, because the statute was written by legislators who are not attorneys or cops or regulated citizens. They're just politicians typically, right? And the conflicting language is, one, a part of the definition of concealed firearm, and then two, the applicability of the license, what it allows a licensee to do, right? So again, not verbatim off the top of my head here. I'm sure you can look it up, but the hit points are this, right? Defining a concealed firearm is unloaded or loaded firearm carried on or about your person, fully concealed or mostly concealed from public view, comma, or carried on or about a person within a vehicle. You did notice that I did not say concealed within a vehicle under the definition, right? This is an important part, right? A couple paragraphs down, it'll basically say this license will permit the holder to, and then I'll basically go back into the carry a loaded or unloaded firearm on or about a person, fully concealed or partially concealed, so it changes those twice, so partially and mostly, right? No definition of that. And then it goes into the vehicle portion saying carry a concealed firearm on or about your person within a vehicle, right? So it adds the language of concealed again. But remember, if we go back to our definition of it, under what a concealed firearm was, it said on or about your person within the vehicle when we talk about the vehicle context, right? And then literally a paragraph later says firearm must be concealed within your vehicle. So which one is it, right? I always defaulted when I taught this, it's very highly recommended to have it, one, out of plain view in your car, concealed, not just for the law portion, but for obviously why would I want a handgun being in plain view if I left it in the car, if I forgot about it, just from a tactical concept, right? I'd rather just have it concealed, right? But from the law portion, people are like, well, what are my rights? What am I allowed to do? Again, these two conflicting statutes right there, or portions of the statute of what it's defined as and what the license allows you to do. Right, so when I read it, interpret that, I'm like, well, concealed firearm is saying on or about a person. So if it's in, on my passenger side seat, if it's in my lap, or if it's tucked away in a glove box, that should all be considered concealed, correct? So no one really had a valid answer on that. I know I'm rambling here, but it's just an interesting concept here. Again, you could look this up on Illinois Concealed Carry Act. It's the first page. You'll see all this, the definition and then what it allows. So we're all kind of running around figuring out what's the best way to do it. Most people are doing the conservative approach of just having it concealed. But I want to know, if I was pulled over and I had it in, say my passenger side seat, can I be arrested for that, right? So I always taught my students, right, concealed carry it, whatever, have it concealed on your body, have it concealed in the car, but if I got stopped here, could I be arrested, right? There is a case law that came out 2019. The arrest happened in 2016, so it was the First District Appellate Court. It is People v. Balark, I think I have how they pronounce it. It's Illinois First District Appellate, which covers Cook County. Again, it was confirmed or affirmed in 2019. The gist of the case was a UUW by felon case, which is unlawful use of a weapon. It didn't really have anything to do with concealed carry, but the court interpreted it based on the Concealed Carry Act, because that was going to be one of the, defenses, right, on the defendant's side of why he shouldn't have been arrested, why there shouldn't have been probable cause for the arrest. So the gist of the case, gentleman was a passenger in a vehicle in Chicago. CPD, one of their tactical units, was driving behind them, witnessed this car burn a solid red light. They try to effect arrest. The car drives for another 45 seconds, so somewhere in between they're fleeing but not fleeing, right? So they stop the car, curb the car. They approach. The main officer is not the driver of the police squad, but he is one of the passengers. So he does a passenger side approach. Upon his approach, right, about 5 to 10 feet per his testimony, away from the car, he observes the front seat passenger, which is Balark in this case, had a handgun in his hand, And then as he's approaching, he takes the handgun and dishes it into his glove box, right? That's the kind of the setup of the case, right? After that, instead of doing like a high risk stop because they were already there at the doorway, they basically instruct all the occupants to keep their hands up. They have all of the occupants, I want to say there was 4 or 5, so a packed car, exit the vehicle, handcuff everybody based on what they saw with the gun. All right. Weird part about the case is all of a sudden, I guess not weird part, it's Chicago, right? I guess the community started getting a little crazy and started interfering with the stop. So CPD officers on scene call for backup, and they end up transporting the vehicle and everyone back to the police station for further investigation. So they had enough to arrest at that point. So I'm guessing they're considering that part the arrest, and then they followed up later on. But they did not find the gun. They didn't search for the gun while on scene. They searched it at the PD. Irrelevant right now, but just interesting. Okay, so Balark, later on they searched the car, they find the gun in the glove box where the officer said it was. So they charged him with UUW by felon because he was a convicted felon. There was also some weed pinch for another occupant, unrelated, right? The challenge of this from the defense was the probable cause to arrest. And basis of that, this challenge, right, was the officer, having a handgun in your hand, right, isn't per se illegal because of the Concealed Carry Act, right? The officer at the time didn't know this person had a FOID or CCL. In retrospect, the guy did not have a FOID or CCL, but the court is treating it as such, right? Because that's the defense. So they're saying this cop at the time, right when this happened, did not know that the gun in this guy's hand or in the glove box was of a concealed carry holder, right? So in theory, it wouldn't be illegal on its face, right? Unless the guy didn't have a concealed carry license, like I said. So they're challenging that. They're basically, it's a lack of probable cause. That's usually what, the defense will attack. And the rest should be quashed, and the evidence should be suppressed based on that, right? Fruits of the poisonous tree, if you've ever heard of that, you can look it up. Because again, the gun was found later on in a vehicle search instance arrest of the vehicle, or a probable cause-based search of the vehicle. I don't remember that part. Doesn't really matter. Anyway, so they, again, arrested this guy, challenged that. The trial court, so the lowest level court, convicted the gentleman, Mr. Balark, and sentenced him to 6 years for UW by felon. He appealed on the basis, I want to say, of incompetence of his public defender, and they actually, was approved on the appeal, and that got pushed up to the First District Appellate Court, which is the next level up. It covers all of Cook County, and they decided to hear the case. So the judge on that case was a bench trial, I believe, and she gave her opinion and went through like 3 stipulations of why the firearm should be concealed in the car. So they actually interpreted it saying that the only real challenge to this would be if the guy had a concealed carry license. So they even said, we know this person doesn't have a concealed carry license, but we're going to treat it as he had a valid one based on the fact that that's his challenge, saying this guy, the cop, didn't know I didn't have one at the time, right? Because they got to be challenged by what is known at the time of the officer. So the court basically gave the defendant a hypothetical or notional, hey, your CCL is now valid during this altercation for our interpretation of what's going on. So that was kind of cool. So they interpreted it like he had a valid CCL, and 3 main reasons of why they believe the firearm needed to be concealed within the vehicle, despite the carry act of the definition they list under there, under on or about a person in a vehicle, right? So the first one is the language of the statute, right? The second language saying when it specifies saying concealed within a vehicle on or about a person, right? Why would they need to put the word concealed in there? They could have just said on or about a person in that. So they added that. Well, obviously the intent of the law was written for it to be concealed. Okay. You can debate that given the definition is different, but whatever. So that's number 1. Number 2 was also saying there's some conflicting language about a driver or occupant / pedestrian's responsibility to notify a police officer they're carrying, right? So they added in the language of the statute a requirement for CCL holders to notify a police officer that he or she is carrying if and only if the officer requests it, right? Some people have this misconception that right when you get stopped by a cop, you have to say, hey, I'm carrying a firearm, and give them the CCL. Only, right, when they ask, right? It's up to you. But if they ask, you are required to tell them, otherwise it's a Class B misdemeanor based on the act. Anyways, so they challenge that, basically saying, this is the state challenging this, saying that why would they list this portion saying you're required to notify a police officer you're carrying, you're also required to tell them the exact location of the firearm, and you're required to allow them to temporarily detain the firearm or secure the firearm for the duration of the stop. So all of these three things, right, or all of these stipulations are going down the road of, well, obviously this law is inferring that the firearm would be concealed. Otherwise, why would the person have to tell the cop that it's where the location is? Because it'd be in plain view. It's like, okay, that's a decent debate and a decent challenge there. And the third one was they challenged the gun in hand was not valid of on or about a person, because on or about a person, a general common law language of that would be on your body, on your belt line, concealed, glove box, somewhere in the car, right? Gun in hand, they interpreted that as not on or about a person, right? It's physically in your hand, well, and that would be in use, so would be invalid on that. So those were kind of the 3 points the court were looking at. They also referenced a bunch of different cases and cited that in the opinion, went back and forth on that. I haven't read those cases yet, but I read this one when it was 20 fucking pages, so long brief, but I was interested in it. My wife was like, what are you doing? I'm like, I'm reading this because it's interesting, all right? So in the end, the appellate court affirmed, which is they agreed with, the trial court's decision to convict the defendant, and they basically said, in their opinion, regardless if this guy had a CCL, a valid CCL or not, he would still be in violation of the act because, again, all those reasons I listed, and they determined that the gun was not concealed because it was on or about a person. The guy was in his hand. So they determined that the gun in hand was not concealed, therefore no go on this, right? If it was in the glove box the entire time, right, it would have been a different story, right? Because you would have to, again, get to the portion of how they got in the car legally, right? But gun in hand, they decided that was going to be not valid as far as being concealed within the vehicle. So what does this mean for us or concealed carry holders out there, especially those that live in Cook County, right? So Cook County, again, falls under 1st District Appellate, as well as obviously the Illinois Supreme Court and the U.S. Supreme Court. So any decision, right, other than a few, outliers, decisions that come down from our appellate court and the Supreme Court are what we call binding. Binding meaning that we are required to follow, right? So it's a precedent in court. All that means is a decision in court based on a specific topic and says this is how we're handling these cases. So any subsequent cases after this need to follow, this language basically, right? Again, there's some outliers that don't require you to follow it, but this one, my interpretation is we would have to follow it. So if you are a concealed carry license holder in the state of Illinois and in Cook County, right? My highly suggested recommendation is if you are in a vehicle, have that thing completely concealed, right? On your body, in the glove box, out of plain view, right? So you don't get jammed up. One, by a police officer that may not know the statute in and out, because they are out there, right? Not all police officers are created equal as far as their knowledge base. Some just don't read the statutes in and out. There's judges and attorneys that do not read the statute in and out, right? Can tell you that for fact, right? So make sure you are looking that up and you are competent in that statute, right? Know what you can and cannot do. So again, my suggestion is absolutely have it concealed when you're in a vehicle, as well as obviously in the public. I think, personal opinion, the defense on this, right, definitely should have challenged and pushed the definition of the concealed firearm, given that it's literally in the act saying on or about a person and not concealed, right? So maybe a non-public defender might have, pushed that a little harder or found some other cases on that, but it's neither here nor there. The state won the case, right? So just thought you guys would, enjoy some of this information. I know I'm like almost 14 minutes deep here, and I know I'm rambling, but hopefully this was, helpful for you guys to try to do this all in one take. I know I stumble and bumble a little bit as I'm driving, but if you guys have any questions, let me know. This is just all based on case law I recently read, and I thought it was interesting. From a law enforcement perspective, I think it's complete bullshit to arrest a concealed carry license holder just because a firearm is in plain view. So if it was on this, passenger seat or, wherever in the car, I could see the gun in hand being an issue, obviously, right? We'll cross that bridge when we come to it. That's kind of a weird thing coming up on a traffic stop. Dude's got a gun in your hand. We're going to treat it as a threat, obviously. But, if valid concealed carry license holder took 16 hours of training, mandatory, paid $150 plus for the class, another $150 for the application fee, et cetera, right? Usually not the guy that's going to try and jam you up on the call, right? They're not going to be the guy pulling the gun on you. But hey, there are some wackos out there. But my interpretation, right, always defaulting to the Second Amendment rights of the driver, occupant, resident, whatever, citizen, I would not be the one arresting based on just because it was in, you know, plain view on the passenger seat. Gun in hand, that's a case-by-case thing, right? But just my opinion, I would not be pushing either a concealed carry law violation or a UW based on it just being in the fucking passenger seat. No go in my opinion. So hope this helped, guys. I know I ramble a lot, but if you have any questions, let me know. I might put this on YouTube or just leave it on Insta, but take care.